This is Democracy Watch. So, Mark, we've had a couple of episodes here sounding the alarm on what I think is the most serious problem that we face right now. You and I have spoken about how Republican gerrymanders across the country are getting struck down thanks to Section 2 of the Voting Rights Act. Those cases are virtually always brought by private parties, meaning firms like yours, and not by the DOJ. But the conservative Eighth Circuit has ruled that private parties can no longer sue to enforce the Voting Rights Act, which means that the states in that circuit are free to gerrymander, and only the DOJ can do anything about it. And of course, they don't have the resources to. Now, Georgia is trying to do the same thing in the 11th Circuit since they want this to be like a national standard. And a lot of Republican states just help things along in Georgia. So what happened here and how much of an impact will it have?
This is critical news because Georgia is at the epicenter of where we need vigorous enforcement of the Voting Rights Act. And what we are seeing is a concerted, planned, aggressively executed strategy by Republicans, including Brad Raffensperger in Georgia, who is the party who's bringing this challenge to the 11th Circuit, to undermine the ability of private litigants, whether it's the NAACP, whether it's my law firm and our clients, but to prevent vigorous enforcement of the Voting Rights Act. And Brad Raffensperger and the Republicans in Georgia are rallying behind them, okay, gathering the troops behind them of more than a dozen Republican attorney generals from other states, not only even from states in the 11th Circuit. This is a nationwide effort to undermine voting rights, and they are using this case in Georgia as their vehicle.
Now, are Republican states targeting private rights of action under any other crucial laws that can impact the election?
Yeah, so they are. This is a full court press. They are challenging under Section 2 of the Voting Rights Act. They are also challenging under another very, very critical voting rights statute, which is the materiality provision of the Civil Rights Act. This is the provision that we've talked about before and that a lot of people remember about naked ballots and misdated ballots. This is a provision that says you cannot throw out people's votes by creating traps for the unwary and making people jump through useless hoops. Think about the old, you have to guess how many jelly beans are in a jelly bar, in a jar, right? These are immaterial to voting. And what Congress said in the 50s and 60s is you cannot condition people's right to vote on these immaterial things. Well, Republicans want to prevent private litigants from bringing lawsuits challenging today's equivalents of those provisions that bear no relationship to the importance of how people vote, but are simply ways of disenfranchising voters.
Knowing that the DOJ, if it's only the DOJ who's able to bring these lawsuits, knowing that they don't have the resources, and then just like gumming up the entire system with useless lawsuits that would take up all of their resources and more insidious ones that they won't have the resources then to fight.
Yeah, I mean, one of the key statistics that I always point to here, and I've written about this on Democracy Docket, that if you go back to 1965 when the Voting Rights Act was passed and you come to the present, there have been more than 180 successful cases under Section 2 of the Voting Rights Act. So minority voters have been protected in more than 180 instances. Only 15 of those were cases brought by the Department of Justice. So that would have left more than 165 sets of in many cases, tens of thousands of voters, hundreds of thousands of voters, but more than 165 instances where minority voters would have been victimized by these unlawful discriminatory voting laws and districts and would have had no recourse. That's before you get to the dozens and dozens and hundreds of like cases under the materiality provision, where DOJ simply doesn't have the firepower to be bringing all these cases.
Just as a quick aside, how many cases has your firm litigated to protect the Voting Rights Act?
Oh my God. We have brought, dozens and dozens. I can't even count, but just in the last, we can rattle off some just in the last few years. We successfully struck down the map in Alabama that discriminated against Black voters. We successfully struck down the congressional map in Louisiana that discriminated against Black voters. We successfully struck down maps in Georgia that discriminated against Black voters. That's just in the last few months.
Yeah.
If you go beyond that, we're challenging, laws, voter suppression laws in Texas and in Georgia and in Florida, all of which are aimed at discriminating against minority voters. And it is no coincidence that Georgia, which has come under withering attack for laws that have targeted Black voters in particular, that they and Brad Raffensperger, who some people think is a hero, Brad Raffensperger is leading the charge to go to the 11th Circuit with this army of right-wing attorneys general behind him to try to gut this very, very important provision.
By the way, the fact that that your firm has been so successful in bringing forward these cases, I hope that for viewers out there, if you're looking to support Marc and his team, the best way to do that is to sign up for Democracy Docket. That's the free news outlet Marc founded to focus on everything voting and elections. It's an amazing resource that I use on a daily basis. So I'll put the link right here on the screen and in the post description of this video. If you're not yet signed up, please sign up. Marc, can you read from the tea leaves that all of these states are eventually going to try and push this position, barring private rights of action in their respective circuit courts?
Yeah, so I'm glad you asked this question. I totaled up all of the attorneys general who have filed an amicus brief in any state, in any case, right? There have been a number of these private right of action cases. The Eighth Circuit case, obviously, where the Eighth Circuit said there is no private right of action. This Georgia case, some others. There are 27 current Republican attorneys general. 22 of them have signed on to this theory in one or more case. Now, why are they doing that? They're not doing it. They're not spending the resources and drafting briefs and signing on just because they want to influence this in other places. 22 states right now have attorneys general who are planning and plotting to gut the Voting Rights Act for their citizens. Okay, that's what this is about. This is not about just what happens in Georgia or just what happens in Arkansas. This is a nationwide push. 22 of 27 attorneys general don't wind up taking this position only to affect other people. They are taking this position because they want to destroy voting rights in their states. And it is a critical moment in our nation's history with this threat at our doorstep.
As far as you know, have any of these claims been appealed to the U.S. Supreme Court? And speak on what would happen if this does go to the Supreme Court.
So this is obviously their plan, right? I mean, this is their plan. They are going to bring this. You almost can't find a case now. If you go to Democracy.com and you look at the database, you can't really find a case now that involves the Voting Rights Act, where either the Republican Attorney General or the Republican Party has not asserted that there's no private right of action. They are trying this in every case. So we can talk about what does it mean if the Eighth Circuit case were to go to the Supreme Court or the 11th Circuit case goes to the Supreme Court. I'm here to tell you they are desperate to get some case to go to the U.S. Supreme Court because they are raising this in every case and just flooding the zone to try to get this to the U.S. Supreme Court. Why? Because they hope that a 6-3 conservative majority will once and for all put the final nail, essentially, in the coffin of the Voting Rights Act, leaving only the Department of Justice as the only entity that is able to enforce it. And, you know, we talk about that they don't have the resources, but what about when Donald Trump was president? We think that they were going to enforce Donald Trump's DOJ was going to enforce the Voting Rights Act, or Richard Nixon's, or Ronald Reagan's, or even George Bush's, right? Like, you know, the fact is DOJ is only as strong as its political leadership is, the Attorney General. And so this is top on their list. This is what they are putting their resources before. Hopefully the Supreme Court won't take the bait. And we can only hope that if the Supreme Court does take the case, they once again summon the courage necessary, as they've done in some other recent cases, to not allow themselves to be used as a partisan tool to undermine the rights of minority voters.
Is there anything to suggest how the Supreme Court would rule on something like this based on past precedent?
Yeah, so past precedent. You know, you and I can talk about Supreme Court and past precedent. I mean, look, I mean, right. This is the conversation people like you and I have off camera, right? Like, on the one hand, yes, there is reason to be hopeful in that the Supreme Court in the recent Alabama case, where they affirmed the striking down of the Alabama map under Section 2 of the Voting Rights Act. You know, it would be a little weird that they said, yes, private plaintiffs, you successfully struck down the Alabama map. Oh, but by the way, no one asked us, but it turns out there hasn't been a private right of action in all these cases
Well,
over the
that's the
years.
thing. Like, if the question wasn't on private, like, could they still say that if the question wasn't on private rights of action? If they were just focused on the legality of those maps, and they just have to rule on those maps, right? But if wouldn't it be different if somebody specifically brought the question of private rights of action to the Supreme Court, because then they can actually rule on that?
The people who want to strike down private right of actions would certainly say so. I mean, for me, I would say, well, Your Honor, you have been ruling on private Voting Rights Act cases since 1965.
Yeah,
And no one asked the question because it was honestly not a question needing to be asked.
right.
Like there was no serious question. And so you cannot now say there is no precedence for finding a private right of action when you have literally, over the course of 60 years, heard dozens and dozens of cases, including recent cases. But, as I said, if viewers want to know what is it that Mark and Brian and others talk about off camera, this is the worry, right? Because look at Dobbs. Look at Dobbs. That was a question, the abortion question was one that the Supreme Court had ruled on directly over the years.
Right.
And yet when the numbers were there for it, when they had the votes on the Supreme Court, they set aside all of that precedent and did some really, really unspeakably radical things as a result. I mean, look at what we're looking at right now in Alabama. Look at what we're seeing now with the tragedy in Alabama about the state Supreme Court ruling about IVF. Look at the radical right-wing effort to ban, women's access to medicine, right? To birth control. So I like to think, when I'm talking to you on camera and everyone's listening and wants to be rallied, don't worry, there's precedent and the Supreme Court will act responsibly. But, sometimes it's not so easy to be so sure.
Well, to that end, what's the solution here? What's the long-term solution?
The solution is that Congress pass the Freedom to Vote Act and the John R. Lewis Voting Rights Advancement Act. There are bills sitting before Congress that would pass with majority support. Let me say that again. There are bills that would pass with majority support. I even think that it would pass with majority support in the House, because some of these scared MAGA types, as they face 2024, some of them might feel pressured when they're the deciding vote. But, Speaker Johnson's against it. Mitch McConnell will have his people in line to filibuster, as they did the last time it comes up. But we need to take control of the House and the Senate in 2024. We need to reelect President Biden. You all can send me all of the nasty emails or post all the nasty comments. I don't want to hear about it. If you are not registered to vote and you are not committing to vote and to drag your fellow friends and relatives out to vote up and down the ticket for Democrats, you are opposing voting rights. You are opposing what we need to do to make this a fairer and more just society. So send all the nasty comments to Brian's feed.
That's right. That's right. Well, obviously, this whole conversation underscores the importance of the work that you do, that the work that's happening in the courts right now. So for those viewers out there who are watching, who are wondering what the best way to support Mark and his team is, it's to sign up for Democracy Docket. So again, I'll put the link right here on the screen and in the post description of this video. I'm Brian Tyler Cohen.
I'm Marc Elias.
This is Democracy Watch.